sir. Uh, this hearing is in the matter of CFY 24-2020 before Her Excellency Justice Maha Mheiri. The hearing is being held by way of video conference in the DIFC court in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al-Tamimi and Company, and the lead counsel is Mr. Patrick Billion Malone, and he is assisted by Mr. Jonathan Brooks. The defendant is represented by Afridi and Angel. Lead counsel is Mr. Sulakshana and Sunil Yaqin. Thank you.
Thank you. Mr. Patrick.
Thank you very much, Your Excellency. This is our application on behalf of the Sunset Parties. I'm getting an echo. There's an echo on the system. I wonder could we address that?
I think it's from your side.
Is it from my side? I'll try again. How's that?
It's better.
Okay, thank you very much. This is our application on behalf of the Sunset Parties in these consolidated proceedings. It's a committal application pursuant to Part 52 of the rules, arising from failure of Ms. Hana Herz to abide by paragraphs 1 and 2 of the order of the court made on the 27th of May 2022. Being a committal application, it has been the subject of the important notice as required under Schedule A to Part 52, which indicates in terms that the respondent to the application, Ms. Herz, must attend before the court. And I think I can show you that immediately. And with your agreement, I think it would be appropriate to know the position before we proceed as to whether Ms. Herz is here today, because obviously that will have a big impact on how we proceed. But if I could refer you to page 7 of the bundle.
Okay.
Yes, thank you. You'll see in terms the notice required by Schedule A to Part 52 is set out there, and that was part of the application that was served and duly served on Ms. Herz, and indeed from correspondence it's clear that she has been served and is aware of the notice. I'll just allow you, Your Excellency, to read that important notice.
Okay.
Yes, and you'll see from that, that from the second paragraph, it does indicate that you must attend court, and because it's in your interest to do so, you should bring with you any witnesses and documents which you think will help you put your side of the case, and that has been done. Now, the court, I hope, has had the opportunity of reading some of the material that's been put before the court, in particular the witness statement of Mr. Ortuno and the affidavit of Mr. Ortuno. Have you had an opportunity to consider that affidavit?
Yes.
Yes, and I think it would be appropriate in the course of this hearing, irrespective of whether Ms. Herz is here or not, that I bring you through the exhibits to that affidavit. Hopefully Ms. Herz is here. Certainly it would be appropriate that she... I'm sorry?
Your Honor, if I may assist, I mean, Mr. Malone can clearly verify whether Ms. Herz is here or not by asking us. She's not presently with us. We understand that her youngest child is unwell. I wonder if Your Honor has had the opportunity to read the note that we've sent to you yesterday. We do apologize about the short timing of that. But one of our main concerns in this entire hearing is the fact that our client has had less than 14 days to reply to what is a consent application that has criminal repercussions. Our client certainly intends to defend herself, but it's our position, or it's our client's position, that the timing is completely against her because of certain personal factors as well as factors beyond her control and other matters affecting the collection of evidence which is required to defend herself. So if Your Honor does consider that her presence is a must, we can certainly take instructions, and this hearing is scheduled for, I believe, 4 hours. So we may be in a position to have her present if it's required. But it may be worthwhile and in the best interest of the court's time to first consider whether a full contempt hearing is to take place today or whether it's more appropriate to give directions so that our client can be more appropriately defended. And I've, in our note, given Your Honor the appropriate rules and the authority, which emphasizes or makes it very clear that a respondent's right to a proper defense is crucial in a contempt application. So I wonder what Your Honor's position is in that regard.
May I hear the claimant's reply to these submissions first?
Thank you. Thank you, Your Excellency. Yes, well, this is not a case management directions hearing. It is a committal application. And primary purpose is to hear Ms. Herz in answer and for her to explain why she has not complied with the orders, obviously in accordance with fair procedures. There seems to be some suggestion in the case management order and the note put forward by Afridi on her behalf yesterday that this is in some way a case management process that could take place according to the timetable under Part 7 of the rules. And under Part 52, of course, the time must be significantly more constrained. But more than that, it is our submission that this application is ready to proceed. It is an application which has been served within and before Ms. Herz for the required 14 days, which is the usual period allowed by this court as a minimum. It is a straightforward case. The idea that there is some complication in this, it just simply does not fit with the facts. Ms. Herz could have complied at any time since she undertook to do so on the 20th of June, which was already 10 days later than the time ordered by the court. But though, in fairness to Ms. Herz, there was, of course, the usual 21-day appeal period that brought her up to the 20th of June 2022. At that point, she wrote to my clients indicating that she would abide by the order and would do so without delay. There was then a sequence of correspondence, but ultimately, as the court will have seen from the affidavit of Mr. Ortuno, the order with the penal notice was served upon her on the 8th of August, and there were many opportunities for her at any day since the 6th of July 2022 to simply go to the Al Barsha DED office or the Al Nasser DED office and fill out the forms. So to comply with the order is a simple matter. I'm sorry. There was some interference there, Judge. To comply with the order is a simple matter. It takes simply a matter of a few hours for these forms to be filled out. They've been placed before Ms. Herz's legal advisors, and they've been with them since the 6th of July. The idea that there is a complicated explanation for failing to do that is something which, of course, the court will consider in the course of today, I hope. But we have not been given the full story, and it makes it very unsatisfactory that a very short explanation has been furnished by a witness statement and not on affidavit yesterday, which raises a number of questions which would require to be examined on oath and cross-examined on behalf of my clients. But our submission in respect of that also is that for the purposes of the committal application, that process may be necessary in order to establish beyond reasonable doubt whether the degree of culpability of Ms. Herz for failing to comply with the order and the manner in which she has conducted herself over the past few months. But it is ultimately irrelevant to the question of her breach of the order. As we've said in our skeleton argument by reference to the authorities, in the case of disobedience of a court order, it is sufficient and necessary for us to show that she knew of the order, which clearly she did, that she acted and failed to act in a manner that breached the order, which we say is clearly the case because the transfers have not been made and it could have been done at any time on any day between the 20th of June and now, and certainly since the 6th of July and now. And indeed, it could be done tomorrow. Ms. Herz could simply attend and sign the forms tomorrow. And thirdly, that she knew of the facts and she knows of the facts, which makes her conduct a breach. And that is simply the end of the matter. The explanation that she has given relating to advice that somehow she procured and was given by officials of the notary public and the DED that encouraged her to transfer all of the shares into her own name and make herself the manager of the company is just an additional factor to her primary disobedience of the order and her failure to comply. Obviously, it's a very serious matter and it's a matter of great alarm to my clients who every day that this position remains the case are being prevented from the good governance of their own companies.
Your Honor, may I be afforded
So the position, I'm sorry, I haven't finished yet. If I might just continue. So if I could ask you to please refer to page 574 of the bundle. Under Rule 52.12, written evidence in opposition to a committal application must be given by affidavit. Now that has not been done here. And it's interesting to note the manner in which Ms. Herz's witness statement was put before the court yesterday. It's described as an appendix to the note to you, not as evidence in answer. It's said to be based on limited instructions. It's said to be not a complete defense. And in the witness statements itself, Ms. Herz says that it's a limited reply. And the witness statement is also undated. Altogether unsatisfactory, but more unsatisfactory than that. Even if following the Latif example, one was to say, well, look, this clearly, Ms. Herz is not here. And in circumstances where she's not here, that evidence ought to be disregarded. And I'll be addressing you on that again later. But if she is here, of course, it is an incomplete, evidently incomplete description of her conduct. In particular, I refer to paragraph 9 of that statement, which clearly calls for cross-examination as to the precise circumstances in which Ms. Herz has come to transfer 100% of the shares of each company to her own name. That in itself, though, is of course an admission that she is in effect in contempt, because she has admitted to transferring the extra 49% of the shares in each company to herself. So instead of transferring 51% away from herself, she has transferred 49% to herself, with the result that none of the shares are now held by my clients. And the order of the court on the 27th of May was precisely the opposite, that none of the shares should be held by Ms. Herz. In addition, Ms. Herz has appointed herself to be the manager of both companies, and that is not engaged with at all in the witness statement and calls for examination. But given the breach of 5212, Rule 5212, together with what is said in the judgment of Justice Martin in Latif, it is clearly a situation where this court must look at whether that witness statement has any value today. If Ms. Herz is not going to be here today, it ought, in our submission, to be excluded from the reckoning. I refer you also then to, on the same page at 574, to Rule 5214, where it stated that a respondent may give oral evidence at the hearing, whether or not he has filed or served any written evidence, and if he does so, he may be cross-examined. And again, I think the court will be aware from the judgment of Justice Martin in Latif that that is a fundamental part of a committal application. So that if Ms. Herz is not going to be here, it may have the consequences that I've just referred to, that her witness statement may be excluded, and it may also justify the court, as we submit, to proceed with the application in her absence and to make an order for committal in her absence with due representation on her side. It is an option open to the court under the rules, and you'll be aware also from the cases, to make an order with an element of suspension, and frequently courts do that in order to allow a last opportunity to the contemnor to purge her contempt. As I've said, and I will be saying again and urging on the court today, it is a singular fact of this case that it would take a few hours, a day at most, for these transfers to be given effect to. The documents allowing for the transfer have been available for Ms. Herz's signature since the 6th of July. But now that she has interposed new facts, new circumstances on the register, obviously to purge her contempt now, she would have to transfer the full 100% to Sunset Rack and to Piatura, respectively, and to reverse her appointment as manager. But that again, those steps are similarly simple and straightforward to take. The idea that there should be huge intervals of a month for the exchange of evidence, allowing for a trial to be fixed sometime in 2023, is an untenable proposition, and the court should not entertain it. In our submission, this case is in fact ready to go on, because we can see already that there can be no doubt that what has been done is a breach, and what has not been done is a breach of the order that satisfies the requirements of Part 52. And the key question is, what is going to be done now to reverse it. The explanations that have been given are not explanations that are capable of of giving rise to a finding that there is no contempt. They are explanations, if true, that are capable of potentially giving rise to some mitigation or to flexibility in your order. But in terms of the readiness, which is the key question under Rule 52.19, I can refer you to that. It's at page 575. That the court may, on the hearing date, either one, give case manager directions with a view to a hearing of the committal application on a future date, or two, if the committal application is ready to be heard, proceed to hear it. Our position is the cases indicate, and I respectfully submit, there are always three interests on, in play on a committal application. The first is the interest of the defendant to obviously time to prepare a defense and to a fair hearing. The second is the interest of the applicant, and in this case, it is urgent and important that my clients be given back control of the companies that has been taken from them, and also that the order of the court be complied with. It is a continuing and serious and urgent matter from my client's point of view. And then the third aspect is, of course, the damage to the administration of justice and the integrity of the court that is done when orders of the court are flouted and disobeyed. And then that is the third consideration here. In our respectful submission, the balance of all of those interests requires that the hearing should go ahead. And I think it is appropriate, I respectfully submit, that we have an opportunity to open the material before you today that's behind Mr. Otuno's witness statement. Ideally, that is something that should be done in the presence of Ms. Herz. And I understand from my friend that she could be available to be present at this hearing, and ideally that would be the case, that she would hear the evidence being opened before you, and then she may decide to give evidence on oath in relation to her witness statement and any other matters, and to be examined by the court and cross-examined by this side. In our respectful submission, that is the appropriate and complete way to proceed. But if it is decided that if Ms. Herz decides that she chooses to absent herself from this hearing, or that she is present but nonetheless chooses not to give evidence on oath, then in any event we should proceed to open that evidence in my respectful submission, and that will give you the best information, the best submissions available for you to make the appropriate order at the conclusion of the hearing.
Okay, thank you. May I ask you wear a headpiece?
Apologies, Your Honor.
A microphone, because there is an echo. So it's your turn to give submissions and reply.
Thank you, Your Honor. I'd like to start off by firstly clarifying my client's position, Your Honor. My client's position has been at all times that she intends to fully comply with the judgment. However, my client completely denies that she has been guilty of contempt of court, as the applicants now allege, on the facts before Your Honor. The limited witness statement that she has submitted to court gives a very clear explanation as to why she had to act in the manner that she did. When she visited the Dubai Economic Department, it was made apparent to her that the trade licenses of the two companies had expired. And Your Honor is well aware that once trade licenses expire, it is impossible to do anything else about those companies. And in order to facilitate the quick transfer of the shares, she was advised by the Economic Department and later on confirmed by the notary that she should first transfer 100% of the shares to herself, so that she can later transfer it back to my opponent's clients. Now, that in itself, Your Honor, is a perfectly acceptable explanation, which our client has provided to Your Honor within the minimum timeline provided in the RDC to mount a defense to a contempt application. Your Honor is aware that under RDC 52.17, it is stated that the hearing date of a committal application shall be not less than 14 days after the service of the claim form of the application notice. Today is the 15th day. She was made aware of the application around 12 o'clock 15 days ago. So she had about 6-7 hours above the minimum required time period under the RDC to even file a reply. Your Honor, it is our submission that there's sufficient evidence before Your Honor to allow our client to properly defend herself in a proper manner. For my learned friend to even suggest that she should be cross-examined before Your Honor before she mounts a full defense is, in my submission, contrary to the fundamentals of natural justice, because she would not have been given an opportunity to even provide her proper explanation with appropriate witness evidence. Now, that would not be cognizant to the proper administration of justice. That would not bear fruit to a enforceable contempt of court order, which ultimately has to be referred to the Attorney General, and the Attorney General, in his view, may reopen or even question the integrity of the order, Your Honor, if one is to be issued without my client being afforded a proper opportunity. Now, the case law, even from the UK, as I provided, Your Honor, is very clear that a fundamental requisite is a requirement for the respondent in a contempt application to be properly heard. And that's well versed in the case of Navigate Equities versus Derek Pasca. I've given the reference in my note, where the judge said that the question of a fair trial was particularly important in the context of a contempt trial where a potentially draconian and life-changing penalty was sought by the claimants, as in the case here. Now, secondly, my learned friend was trying to say that the case management order that we provided to Your Honor thinks of a trial somewhere beyond December 2022. Now, Your Honor, the case management order that we've suggested is in respect of the present contempt application before Your Honor on the facts presented by the applicants. It does not suggest that our client will not comply with the order until the hearing of this contempt application. Those are completely two separate things. We've reiterated over and over again, our client has reiterated that she completely and fully intends to comply with the order as soon as is possible. Now, once the shares are transferred to her name, it has been extremely difficult for our client to get the cooperation of the applicants to transfer the shares back. Now, that's a matter, like my learned friend says, can be done in relatively short time. Now, if the applicants do cooperate, then that could be done and dusted with. However, the matter remains that this contempt application has been prematurely filed and it has to be disposed of because my client's reputation, my client's reputation is at stake, and a contempt application is a serious matter that should be properly defended against. So, in my respectful submission, Your Honor, the hearing of this contempt application, the rush nature that the applicants are suggesting today, has nothing to do with the compliance of the judgment which my client fully intends to comply with. It is an administrative matter. It is a matter of natural justice, and it's a matter where this court's integrity is being questioned because a contempt order is being sought by my learned friends with very limited evidence, without an opportunity for our clients to properly mount a defense, and there's a perfectly reasonable explanation as to why she acted in that manner, it would not be appropriate in my submission for the court to proceed today in the manner that is suggested by my learned friend. Now, if there is my learned friend himself was also heard to say that Ms. Herz has not given the full story and that there's a lot to be found. And that's exactly our case. My client has not had the opportunity to give the full case because of a number of issues and the very short time period that she was afforded to defend herself. Now, my client has, like I said, if Your Honor is of the view that she has to be present in court, we will take instructions on the issue. But we respectfully and strongly submit that it is not appropriate for the court to proceed with the committal hearing today, given the circumstances that were submitted. My client fully intends to comply with the order, regardless of the timing of the committal application, which we've suggested, and obviously the dates can be discussed between the parties if Your Honor is so minded. And there's really no injustice caused there's more injustice caused to my client than to my learned friend's client if the hearing were to proceed today. I would rest at that, Your Honor.
You're on mute, Mr. Patrick.
I'm sorry. Your Excellency, if I might briefly respond.
Yes, briefly, please.
Thank you. First of all, there is no evidence before the court to suggest that our application was prematurely filed. It is clear in our submission from the sequence of correspondence and from the sequence of events that the application was made promptly and appropriately at the time when it became clear to my clients for the first time that the 100% of the shares in both companies had been altered, but that had been vested in Ms. Herz. There had been no mention of this, of course, by Ms. Herz in any of the correspondence during July and August. No mention at all that these steps had been taken, and nothing since. The idea that there has been insufficient time also doesn't, in our submissions, fit well with the explanation that she gives briefly, that all along she was taking independent steps to try and comply with the judgment, because that can be explained and could have been explained in our submission very quickly at any time during the last 14 and 15 days. I note from my friend that he will take instructions to see whether Ms. Herz will come to attend today. I think that is the course that this court should now definitely take. It is the purpose of this committal hearing that Ms. Herz be here, that she be here to answer why it is that the transfer orders have not been complied with, and for submissions to be made on her behalf in that regard. Also, as I've already indicated, I think it is ideal in circumstances where the application ought to proceed because it is ready to proceed, that she be here to hear the evidence opened before you.
Your Honor, may I make a very short submission?
No, thank you. I heard enough from both parties. I've came to a decision to adjourn this committal hearing for 2 weeks. on 4th of October, we'll have another hearing in relation to this committal application. There will be no further adjournments. So anything that wants to be done from the defendant's side should be done within these 2 weeks, and then we'll take it from there.
Your Honor.
Mr. Patrick, you're on mute.
Thank you, Your Excellency. There is power in the court to give directions for the submission of evidence. Obviously, at present, the requirements of Order 5212 have not been met by the provision of a witness statement, an undated witness statement, when it ought to be evidence on affidavit. It is important in committal proceedings that where evidence is given, that it be given on oath, and I respectfully request that the court direct that if any evidence is to be relied upon, that given what has happened so far, that the court remind Ms. Herz of the importance that the evidence be given on oath, and also to call attention to the consequence as found by this court in Latif. Sorry, I'm getting a terrible feedback. Will I start again, Judge? Did you hear me?
Yes, I did. Please proceed.
Thank you. Just to say, I think it would also be appropriate to indicate that the consequence of filing evidence, even in affidavit form, and not being available on the return date for cross-examination, may lead to consequences that the application may proceed in the absence of Ms. Herz, and that any evidence filed by her may be excluded in accordance with the principles identified by Justice Martin in the Latif case.
Yes, I do agree with that.
Your Honor, our client and this firm is quite above the rules, and we will certainly follow the rules as required without the assistance of Mr. Malone. But thank you very much for that.
Thank you both for your time. You will receive notification of the hearing through email.
Might I just mention the issue of costs? We have a statement of costs before the court, and I appreciate that the application is continuing, but nonetheless, it is the case, and I wish to put on record. Can you hear something, some feedback here? I wish to put on record that we have been brought to the door of the court today by a failure to engage and a very late and piecemeal engagement just yesterday afternoon by Ms. Herz, and in the circumstances believe a costs order for today of the costs thrown away of the hearing today is appropriate, and I respectfully request that an order be made now for the costs thrown away of today.
Your Honor, may I reply?
Yes.
Your Honor, we have indicated as far back as Thursday of last week to Mr. Malone and his clients that it would be more appropriate for our client to be given adequate opportunity to reply to this application. On the very next day, they stubbornly replied and said that would not be the case and the hearing would not be adjourned. And the outcome of the hearing was that it was adjourned. So if there's any cost orders to be made, it should be in favor of the party that proposed the reasonable steps a few days ago, and that was certainly our client. So if any cost orders are to be made, that matter should be taken into account, Your Honor.
Okay, thank you for your submissions. We'll send through email the directions in relation to costs. You're on mute. You're on mute.
I'm sorry, Judge. My colleague has told me there was some interference on my computer, but I've understood your order. Thank you.
Okay, thank you both for your time. Thank you.
Thank you, Judges.